Everyone, before you enter the contract to examination hall, let's do one final revision of the sections and case laws that you absolutely should not forget. I'm not going into lengthy theory here. The goal is simple. If a question comes in the exam, you should immediately know which section and which case law to mention. Let us start with the Unit 1. When you hear contract of indemnity, immediately think of Section 124. Section 124 gives us the definition of contract of indemnity. And if you want a case law, remember Adamson versus Jarvis. The story is very simple. A person acted on someone else's instruction and later suffered a loss. The court said that if you ask someone to do something on your behalf and that person suffers a loss, you must compensate him. So whenever you see indemnity, think Section 124 and Adamson versus Jarvis. Now let us move to guarantee. This is one of the examiner's favorite topics. The first section to remember is Section 126. The section defines contract of guarantee and introduces the three parties: creditor, principal debtor, and surety. Now is the question shift. If the question shift to liability of surety, immediately write Section 128 and remember this golden line. The liability of the surety is co-extensive with that of the principal debtor. If the principal debtor owes the money, the surety can also be called upon to pay. Now another important area is discharge of surety. For this, remember three sections together: Section 133, Section 134 and Section 135. Think of them as a package. 133 is variation in the contract. 134 is release of the principal debtor. 135 is composition of or giving extra time to the debtor. These three sections appear again and again in the examination. Now let us move to Unit 2. When you hear bailment, immediately think Section 148. That is the definition section. And when the question asks about the duties of a bailee, think Section 151. This section talks about reasonable care. And this is where the famous case Cox versus Bernard becomes important. The facts are easy. A man agreed to carry goods without charging any money. The goods got damaged because of negligence. The court said that even if the service is free, reasonable care is still required. So the memory line is: free service does not mean free negligence. Now let us talk about liens. Section 170 gives particular lien. Section 171 gives general lien. Examiner love asking the difference between these two. Then come pledge. Section 172. And remember one golden sentence: every pledge is a bailment, but every bailment is not a pledge. If you remember this one line, half the answer is already done. And if you want a case law, remember Lallan Prasad versus Rahmat Ali. The principle is simple: the pawnee gets possession of the goods, but ownership remains with the pawner. Possession is not ownership. Now let us move to the Unit 3. Agency starts with Section 182. Wherever you see agent and principal, think Section 182. Now one topic that students often find confusing is agency by ratification. Don't overcomplicate it. Imagine your friend acts on your behalf without authority. Later you approve that what he did. That's ratification. Authority comes later, but the act becomes valid from the beginning. That is why I remember it as authority later, validity earlier. Now let us talk about termination of agency. This answer becomes very easy if you remember 6 headings: revocation, renunciation, completion of business, death, insanity, insolvency. Write these 6 headings and your answer is practically ready. Finally, let's come to Unit 4, Government Contracts. The most important provision here is Article 299, and instead of memorizing the entire article, remember just 3 words: name, authority and form. That's the entire logic of Article 299. And if you need a case law, remember State of Bihar versus Karamchand Thapar. The court clearly stated that Article 299 is mandatory, not optional, mandatory. Now let's finish with government liability, and here you only need to remember 2 names: Vidyavati and Kasturilal. In Vidyavati, the government was held liable, so remember Vidyavati equals liability. In Kasturilal, the issue was connected with a sovereign function and the court took a different view. So remember Kasturilal equals no liability. Now let's do a final 20-second revision. Section 124 Indemnity, Section 126 Guarantee, Section 128 Liability of Surety, Section 133 to 135 Discharge of Surety, Section 148 Bailment, Section 151 Reasonable Care, Section 170 Particular Lien, Section 171 General Lien, Section 172 Pledge, Section 182 Agency, Article 299 Government Contract, Article 300 Government Liability, and the cases: Adamson vs. Jarvis, Cox vs. Bernard, Lallan Prasad vs. Rahmat Ali, Karamchand Thapar, Vidyavati, Kasturilal. If you remember these sections and case laws before entering the examination hall, you will be able to strengthen almost every major answer in Contract 2. Good luck for your examination, and I will see you in the next revision video.